Our lawyers here, James and Eric, will be doing a presentation where hopefully they will be answering a lot of the questions that you have. But if there are things that have not come up that you need questions for at the end, we will have a question and answer period. What we'd like to do is have people use their raise hand function. If you click on the bottom of your screen on participants, you should be able to see a list of participants that come up, and you'll be able to raise your hand to be able to ask a question. I will call on you. If we get to the end of our time and we have not gotten to all of the questions, I will ask you to type them into the chat, and we will try to do a frequently asked questions at the end that we can get out to everybody, try to get to everybody the information that they need. And I guess with that, I will turn it over to Eric and James to introduce yourselves.
Good afternoon, everybody. My name is Eric Chester. I'm here with James Demetriades. We're attorneys with Ferguson, Doyle, and Chester. We represent AFT Connecticut, and with that representation, we obviously represent all of you in a number of capacities and a number of forums. We're going to be presenting to you on a number of issues. As Jen said earlier, hopefully we'll be able to answer most of your questions. I can guarantee that we will not be able to answer all of your questions. There are some questions that don't have answers yet. This is all new. None of us would have anticipated being in the situation that we're in. I will also say at the outset that I empathize with the anxiety that a lot of you are experiencing as the schools face reopening in a couple of weeks. I think it's pretty telling that all of us are meeting this way, like virtually. However, all of you will be expected to be meeting face-to-face with large numbers of students in the coming weeks. And with that comes a lot of anxiety. And we certainly appreciate that and commend you for what you're doing and what you will be doing when and if your schools reopen. I'll let James just say a couple words, introduce himself, and then we'll start the presentation. And what we envision doing is going through a PowerPoint presentation, going through some slides. There'll be a point in time where we can take a break to address some questions about the topic we just covered. And then we'll try to cut it off at some point in time so we move on to the next topic. That way we haven't gone through a number of topics and then prohibited you from asking a question at that time. James?
Yeah, thank you, Eric. Hello, everyone. My name is James Demetriades. I'm one of the attorneys here at Ferguson, Doyle, and Chester. I want to echo Eric's comments, particularly the poignant one about we're all meeting virtually, and yet you're all going to be asked to return to work in the fall in person. And so our goal here is to help get you guys the information that you may need to make sure that your return to work is as safe and secure as possible. I also want to say that I appreciate the work of educators. My mother is a going on 14-year paraprofessional in our home district of Cromwell, so I know a lot of the struggles, the day-to-day struggles that happen. She works with K through 2, so I can only imagine the lived experiences of everyone here in this meeting. But hopefully today, like Eric said, we will be able to answer some basic questions and kind of do a overview of the most frequently asked questions and topics. And again, we may not have the answer for everything, but we are here to start the conversation and discussion, and through our PowerPoint, through our FAQs, and then through our collective knowledge and resources. So thank you all for what you do, and I hope you enjoy the presentation.
And just a moment. Okay, can everybody see the presentation? You're there? Okay. So we'll be talking about COVID-19 and reopening and some of the issues that you're going to be faced with, and hopefully, again, answering some of the questions. And Jen, if you, for any reason, you see that I'm doing something wrong, something pops up on the screen that shouldn't be there, by all means, let me know. Okay, some of the things we're going to be talking about this evening. And there have been a lot of questions about ADA accommodations. Of course, ADA is the Americans with Disabilities Act, and we'll talk about that process. We'll talk a little bit about the CARES Act and some of the benefits that are afforded to you under the CARES Act. HIPAA, some HIPAA concerns. The HIPAA, of course, is the federal law that pertains to maintaining privacy regarding medical records. We'll talk a little bit about something that we hope you don't have to experience, but some undoubtedly will, is unemployment benefits in relation to the pandemic as well. And of course, we're going to be taking questions as we go. So ADA accommodations, a little bit of background information. Again, this is a federal law. This is the Americans with Disabilities Act. It talks about, discusses who qualified individuals are under the ADA. And a qualified individual is someone who, with or without a reasonable accommodation, can perform the essential functions of employment. I'm sorry, let me just move this. The position that they hold or that they desire to hold. Okay, so that is the definition of a qualified person under the ADA. All right, so who is qualified as a person is disabled if the individual has a physical or mental impairment that substantially limits a major life activity, or is a person who is regarded as having a disability. And that doesn't really pertain to this presentation. But again, it's someone who's been diagnosed with a physical or mental impairment that, second prong, substantially limits a major life activity.
And I don't want to fit here. Oh, I'm getting a little bit of feedback. I'm sorry about that. So a major life activity, I often get questions about what that means. So major life activities is something that you need in order to maintain your standard of living. Often they say it's mobility related, eating related, bio facilities, bathrooms, things like that. So you have to think about what your major life activities are for you to be able to conduct yourself at the normal or peak standard of living. And so that is when you do have a physical or mental impairment, you have to ask, what does it limit and what major life activities does it limit as you're thinking about it. And I do also want to point out that qualified individuals under the Americans with Disabilities Act are you. You're the individual person. It is not a brother, a sister, a child, a spouse, a parent. Those folks would not be a qualified individual for the purposes of an ADA accommodation. It has to be a condition that you have. So that's a question that often comes up with, well, am I a qualified individual?
Thank you, James. All right, so the essential job functions. An employee must be able to do the essential job functions with or without an accommodation. In other words, for those of you who are teachers or paras, you have to be able to perform the essential functions of your job. You have to be able to teach. Again, the term essential functions means these are things that are fundamental. They're fundamental duties of the employment position that you hold. A classroom teacher rarely is going to be required to lift a significant amount of weight overhead. So that wouldn't be an essential function of their job. But certainly, you would need to be able to deliver instruction to your students. That certainly is an essential function of your job. Whether or not you need to do it face-to-face or whether or not you can do it remotely, we'll get into when we're talking about accommodations. Okay, so a reasonable accommodation. It's a modification or an adjustment to the work environment to allow the employee to conduct or to carry out the essential functions of his or her job. It can include things like, and this is not an exhaustive list, these are just some examples. It can include things like a modified work schedule, a reassignment to a different position or a different location, some type of modification of a physical modification of the facility, plexiglass, for instance, or those types of things, or the use of an interpreter. Those are your kind of your run-of-the-mill examples of accommodations for a qualified individual. Now, the employer legally must provide the accommodation unless they can show that it would be an undue burden or hardship on the employer. And this is where the reasonableness becomes a term of art, right? This is really where the rubber meets the road on a requested accommodation. An employee says that they need an accommodation due to a qualifying disability, and the employer may look to show that the requested accommodation presents an undue burden. It's just either too expensive, impractical, impossible. The employer just cannot meet that accommodation and still run its enterprise or its school in this case. And that balancing test often, is the subject of litigation in these types of cases. Is the requested for accommodation reasonable, or does it place an undue burden or undue hardship on the employer? James, do you want to add to that? I think you're muted, James.
Yeah, I am indeed. Okay, so as these slides kind of show, there is no perfect formula for this, and it's often subject, like Eric said, of a lot of litigation. So the question you have to ask yourself when approaching an ADA accommodation is, for after you get past, do I have a qualifying disability? The next question you have to find out is, what would be some reasonable accommodations given my restrictions? And we'll get to this a little further down, but what is helpful to consider is, what are your essential job functions? And a good way to find that out is look at your job posting from when you applied. That will be give you a pretty good idea of what your job description and essential job responsibilities are. And how can you, with an accommodation, continue to be able to do that? So, for example, if you have and I'll give you a classic example, a non-COVID related example. Let's say you break your leg. And you have a permanent inability to walk upstairs because of the way that your legs healed. Reasonable accommodations that would still enable you to do your job would be to have, if you have a multi-level school, for your classroom to be closer to the front of the building, for your classroom to be near the office or near the copier room where you go frequently. To have a teacher aide or somebody else help bring your students to the cafeteria so you can avoid excess walking. Perhaps providing a stool or a wheelchair for you in the classroom. What would not be a reasonable accommodation is, let's say the school, for whatever reason, doesn't have, there are front steps that have to be walked up in order to enter the school. Building you your own ramp may not be a reasonable accommodation. If you, for another example is, let's say you want a classroom closest to the office and you're the only one they're able to provide you is 2 away from the office. That's reasonable. It may not be the preferred accommodation, but it's a reasonable accommodation, given that maybe the first office is the nurse's office and that needs to be closest to the office for medical reasons. So it's an interactive process, and that's going to be our next slide, actually. A little bit of a back and forth. So Eric, if you want to go to the next one, I can talk through this. So if all of the preconditions that we discussed earlier are met, if you have a disability, if you're able to do your essential job functions, you engage with the employer in a interactive process. Now, there's no magic words to begin this process, but what I would suggest is that you put in writing to either your HR manager or your building principal, I have a qualified disability. Here are the restrictions that my doctor has put me on. Here are the recommended accommodations, and here's an attached doctor's note. And again, the employer does not need to provide you with the preferred accommodation as long as their suggestion or accommodation is reasonable. And then number 3, the employer can ask questions about your condition, ask for medical documentation, and ask for documentation of restrictions. Some districts have a form that they may require your doctor to fill out. This is not a violation of HIPAA to do so. The schools need to know what they're accommodating. So recently, Eric and I have gotten a flurry of questions about surveys that schools are sending out, asking about, do you have a pre-existing health condition? And people have said, can they do this? Isn't this a violation of HIPAA? And what the answer is, they can ask if you have a disability if you are going to be seeking an accommodation. So if you need an accommodation and you think in the fall you may need an accommodation, you have to give the employer the information upon which to understand what your restrictions are, what your disability is, and what the potential accommodations are. When you do ask for an accommodation, it's helpful for you to come up with what a couple possible potential solutions would be given your circumstances for you to kind of negotiate.
I could just, one couple things on this too. You know, what James has said is absolutely right. The employer, it is reasonable and permissible for the employer to inquire as to what the disability is and what the restrictions are. You have to give the employer the opportunity to afford you the accommodation, and they're going to need some information. Of course, that doesn't mean you're giving them unfettered access to your medical history. You're not. You're not going to sign a medical release so that the employer can write to your doctor and get whatever they want. You're not going to do that. You're going to provide only the necessary information to substantiate or corroborate the disability and the restrictions and the need for the accommodation. The other thing I wanted to say is, and I fielded a couple of these questions / concerns about, can someone, a teacher, a para, quote unquote, write themselves out of a job? Mm-hmm. I think it's very important that if you find yourself in a position where you think you need an accommodation, one of the first people you're going to talk to is your healthcare provider, your doctor, your PCP, whoever it is that's treating you. And you want to make it very clear to them that you can still teach. I can still work. I can still do the essential functions of my job. I just can't do these 1, 2, or 3 things. The last thing you want to do is provide your employer with a note from a doctor saying that you're medically unable to do your job. So you know, be cautious about that. And of course, if that happens, that's a different scenario. If a teacher is legitimately medically unable to do their job, then that, you know, we're talking about different issues there. But for those of you who are able to perform the essential functions of your job, however, just have some restrictions that then warrant an accommodation, make sure that the medical documentation you provide is narrow and doesn't suggest that, you know, you can no longer perform the essential functions of your job.
And one other point that Eric makes me think of, this interactive process takes time. It takes time for you to get the doctor's note. It takes time for them to review it. It takes time for them to set up a conversation with you. And they're probably going to be having a lot of these conversations. So don't wait until, you know, the first day of school to say, hey, by the way, building principal, I need an accommodation. Hey, HR, I need an accommodation. You got to be starting those conversations now. You have to be going to see your health provider now and saying, listen, you know, can I safely return to work? If I can, what are you suggest? Do I need to have additional PPE? Do I need to have plexiglass? Do I need, you know, starting those conversations now and not waiting until the end of August, beginning of September to have it. I think that's really important.
Want to continue, James?
Yeah, sure. So COVID-19 is obviously a very unique and continuingly developing situation. There's nothing like it. There's not a lot of precedent based off of it. So we're using existing law to fit into a puzzle of something that's quite novel. But here are some general COVID-19 considerations for us to consider. Having COVID-19 itself is not automatically a disability. It's a case-by-case based on the symptoms of the disease and the effect. So employees who are at high risk of serious health problems or death if they contract COVID-19 may be entitled to an accommodation under the ADA. However, that employee must still show that they have a disability. They must still show that they can do the essential job functions, and they must show that the requested accommodation cannot or does not cause a undue hardship on the school or the employer. So let's say, and the next slide will have a list of some of those conditions, but let's say you have a qualifying condition that's been identified by the CDC. So we'll go to the next slide and I'll give you an example. So you are immunocompromised. You have an immunocompromised state. You just had an organ transplant. I think that's a good one to use as an example. You're immunocompromised. You can't be exposed to the virus because most likely it would cause you to suffer really bad consequences. And all of these are identified as at increased risk by the CDC. You have to show that you have a disability. You know, because of my organ transplant, I have difficulty processing, you know, blood flow. I have difficulty breathing. I have difficulty doing something. And then, you know, the COVID-19 would cause exacerbated symptoms of this, you know, my recent organ transplant, and may cause it to fail. Therefore, I need an accommodation where, you know, my classroom is sanitized every single day after every student leaves the room, you know, or whatever it may be to minimize the chance of exposure. So on this list, we have cancer, we have chronic kidney disease, we have COPD, immunocompromised state from organ transplant, obesity, serious heart conditions such as heart failure, coronary artery disease, or cardiomyopathies, sickle cell disease, and type 2 diabetes. So all of these conditions are identified by the CDC as increased risk. You still have to have a doctor's note that demonstrates how these conditions cause you to have some type of issue in a major life activity that in turn would prevent you from being able to safely carry out all of your duties without the accommodation. The second set of conditions are the ones that place you at a potential risk. So these are asthma, cerebrovascular disease, cystic fibrosis, hypertension, high blood pressure, regular immunocompromise from, you know, whether it's bone marrow transplant, regular deficiencies, HIV, neurological conditions such as dementia, liver disease, pregnancy, pulmonary fibrosis, smoking, thalassemia, or type 1 diabetes. So all of these are things that have a potential risk. Now, just because they're in the potential risk category doesn't mean that you personally might not suffer severely from it. Increased risk and potential risk, there's the two different categories designated by the CDC. If you have severe asthma, for example, and your doctor says, listen, you have really severe asthma, you shouldn't be wearing a mask. A reasonable accommodation you could request for that situation is, I need a face shield. I need a plexiglass barrier around my desk so I can continue to teach, but I can't wear a mask while I'm doing it, and I need to have that kind of protection. So each and every one of these is individual to you. So one person may be asthmatic but can wear a mask, but another person may not be. So this is where having that relationship with your doctor is really important to figure out what do your conditions or conditions collectively restrict you from being able to do.
And if I could, James, you know, this is going to be, especially with this category of conditions, it's going to be very important as to what the specific facts are and what the treater puts in his or her report. The asthma example that James just gave is a perfect one. You'd be hard pressed to seek an accommodation by presenting a note from your doctor saying, I have asthma. That in and of itself would not carry the day. The report would need to say, to use James's example, I have severe asthma, which prohibits me from wearing a mask, a face mask. However, I can still do the essential functions of my job, and I need this reasonable accommodation. I need the face shield. I need the plexiglass, whatever it is, okay? So again, having that conversation with your treater and having that clearly reduced to writing in the treated report is going to be pretty important. Of course, being pregnant is not a disability. We all know that. Certainly neither is smoking a disability. However, given the pandemic, being pregnant does certainly cause potential problems for someone being in close contact with someone who might have the virus. So again, if your treater feels that a teacher or para being pregnant puts them at a heightened risk of contracting COVID, puts the child at a heightened risk of contracting COVID, they're going to want to specify that in their report and suggest what the restrictions and or accommodations might be. Okay, so what we plan to do here is take a pause. We've been talking for about a half an hour now, and maybe field some questions, Jen, through the raised hand mechanism. And I'm going to stop sharing my screen for a moment.
Sure.
And just as a disclaimer for people who are asking questions, we are going to be talking about the CARES Act, more HIPAA, and unemployment later. So if your questions relate to the CARES Act types of leave, HIPAA issues, and with unemployment, let's wait until those portions of the presentation come out.
Okay, so we will start with Linda R.
Okay, I have two questions that we were talking about. First,
Linda, I'm having a hard time hearing you. Can you repeat
Yeah.
that?
Same.
sorry. Can you hear me now? How about I'll type my question in the chat?
If you lean it, when you were leaning in closer, it came through.
Okay. Do you need to have FMLA paperwork or some particular paperwork to ask for the accommodation? Or is that just strictly like with the notes from the doctor? And then James, I sent you the other question just because I didn't know how we were going to do this, but I am immunocompromised because I have an autoimmune disorder and I'm on an immune suppressing drug. And my HR told me not to fill out paperwork for FMLA because I may not qualify because it's considered a fear. But I'm in the high school and I'll be in one cycle of students at the 50% around 128 people in that time. It's not elementary or middle, and I don't even know how to ask to try to be confined to smaller groups and how to do that.
Yeah, okay. So no, I hear you and I understand you. And so first off, let me just clarify that asking for an ADA accommodation is different than asking for FMLA or to use FMLA. They're different categories. So there's not a magic word to start an ADA accommodation process, but it's probably a good idea to have a letter written out that says, you know, dear principal, dear HR, you know, please see the attached note from my doctor, which identifies, you know, in the scenario you just gave me, I'm immunocompromised. Here are the restrictions. You know, I am more susceptible to catching diseases and viruses. COVID-19 would cause, you know, complications in relations. I would need some type of remote work and or some type of hybrid remote work or extreme cleaning regimen in order for me to be able to be safe in these classrooms, given the volume of students I'm having. This is my request for an ADA accommodation meeting. And then at that point, they may say to you, can you provide us with more documentation as to, you know, X, Y, Z, and start that process. Now, the question about FMLA, right? To be eligible for FMLA, there's four broad categories. The birth of a child, if you are adopting a child and you need to go through the foster care process, to care for an immediate family member with a serious health condition, or to take medical leave because of your own serious medical condition. So during your ADA accommodation discussions, it may come out where they said, you know what, let's revisit this in 30 days, take FMLA for 30 days. Let's see if the numbers go down to an amount that cleaning the classroom every day would be tolerable. But that's individual to you and to your conversation and to your discussion with your restrictions. So FMLA can be part of the recipe of the ADA accommodation, but it wouldn't be the first recourse, right? Because you want to be able to say, I can still do my job. I can do it safely. Here's how I can do it safely.
And I would say too that I'm sure that every school district is going to have a mechanism to deal with these ADA requests. We've seen a number of reopening plans. We've seen a number of districts sending out these surveys. And districts know, and they've been advised by the governor's office, by your unions, that they need to come up with a process to handle ADA requests for accommodation. So every district's going to be different. Every district's going to be unique. And like James said, there isn't one way to do it. I would, starting now, find out from the district what is the ADA process, you know, and you could write to somebody, and if there is a form, use it. But if there's not, you don't need to use a form. You can a simple letter saying that you have a disability, you need an accommodation, that kicks off the interactive process.
Because I sent a letter requested that I be allowed to work remotely, you know, came from the rheumatologist, and the written said they're not allowing any remote positions. So I didn't know where to go from there.
Yeah, so we've I think both Eric and I have encountered that, and the problem is this is district to district. Each district may have specific plans, but if one district's not offering virtual learning for anyone, that is that district's policy. We have to find other ways to try to get you accommodated. I will also say that DOL's put out some guidance that said just fear of catching COVID-19 is not enough to be able to claim FMLA. It has to be, you know, more substantial than just a fear. It has to be a demonstrated, I would say it would have to be a demonstrated medical necessity for you to do it. But be careful, because if you're saying you can't go back to work because you have a serious health condition, they can just say, well, you can't do your job. You can't do your essential job function. So you always have to make sure that whatever you write still says you can do whatever your job title and job responsibilities are.
And Jen, should we go on to the next question? Or there's a lot, I see a lot of hands raised. I don't want to cut you off, Linda, but a lot of people are in the queue waiting to ask their question as well.
Okay, so let's do Martha Rowland.
Yes, actually my issue is similar to Linda's, although I did file the FMLA paperwork. I have a number of risk factors, including autoimmune. And at first it was approved when the plan was for us to go back, everybody attend, before the hybrid plan was implemented. But then I found out this morning, no, because we're going hybrid, it's not approved. And that's because in the paperwork, technically, I can do my job functions. It's just that I need, you know, the social distancing, you know, so in other words, the FMLA paperwork doesn't ask the right questions for COVID because we haven't had a pandemic. You know, it asks things like, can you do your duties? Well, technically, yeah, I could, you know, but I'm in very high risk. So anyway, so that's what they said, was that, you know, now it's been revoked. And so I asked, well, can I have a 6-foot bubble? That's, you know, the CDC recommends 6 feet for social distancing for high-risk individuals. And I have not got an answer on that. They referred me to my principal. My school is overcrowded. Even with 50% in the school, there's no way that they can maintain a 6-foot. I mean, I email my principal, but it's kind of a moot point because I know we're so overcrowded, you know? So I don't know where to go from here. I mean, they've got my doctor's note, they've got the FMLA, you know, paperwork. And like I said, they're not guaranteeing 6 feet. Do they have to follow the CDC?
Well, you asked a great question, Martha. And first off, you said that you applied for FMLA, not necessarily an ADA accommodation.
Yes.
Okay.
Which is what I was advised by HR.
Okay. And, you know, like we said earlier, FMLA can be part of or an ingredient to an ADA accommodation to grant you FMLA for a period of time while either you recover or they work out the accommodation that you need. But they still are obligated legally to go through the interactive process of the ADA that the ADA requires. So I would suggest that you specifically apply for an ADA accommodation. Let them know the FMLA is one thing. However, I'm applying for an ADA accommodation. Specifically, my doctor has suggested that I have these restrictions and I need these accommodations. That puts them on notice that they're in a different forum now.
Mhm, mhm. Okay. How many weeks does ADA, I mean, is that a permanent? As long as the risk is active, is that a permanent accommodation?
Not necessarily. Remember, it's contingent on a number of factors. And it really comes down to the reasonableness of the accommodation. So it can be unreasonable for it to be a lengthy period of time.
Okay.
Or it could be unreasonable even if it's for one day, but it presents the employer with an undue burden or hardship. So the length of time is just one of a number of factors that will be looked at as to whether or not the requested accommodation is reasonable.
What I would suggest is that right now the Equal Employment Opportunities Commission, which is the federal agency responsible for enforcing anti-discrimination laws, they put out guidance that said, normally you need to come up with an accommodation that is for the duration of the disability. Like, let's say if you have carpal tunnel or you have some back pain or back conditions and you need a standing desk. You get the standing desk as long as you're working there. You get the modified typing as long as you need to type. With COVID-19, they say you can consider a temporary accommodation. So something you could do is say, let's do an accommodation until September 30th and then meet again to reevaluate. Perhaps we set a metric saying, if the infection rate goes above a certain percent, let's get together and reevaluate. And I think doing temporary accommodations is something that they're allowing now and something that ordinarily wouldn't be allowed, but is something you can explore in lieu of. And again, like Eric said, this is all part of the puzzle that has to be fit together, all part of the factors that have to be considered. And unfortunately, because it's so novel, there's not, to your point, right? It's not a perfect fit all the time. So it's working the different parts together.
So, okay, so I have 5 weeks accumulated sick leave. Would it be better to start there than an ADA accommodation, or start with the ADA accommodation?
Start with your ADA, and this is my general advice to everyone. Start with an ADA accommodation. The worst, as long as your doctor's note doesn't write you out of a job by saying you can't do your job at all.
Sure.
As long as that's not the case, you can start by saying, here are the conditions I want, and negotiate too. Well, once a week, that day, I'm going to take a sick day on when these certain things have to happen because I just can't come in. But however, I will record my lecture for for it to be played. You could, but again, this is such an individual process that's to you, your healthcare provider and the building administrator or HR person to negotiate how that would work or how that would look.
Yes,
So,
absolutely, Martha. Start with the request for the ADA accommodation immediately. Provide the documentation that corroborates your need for that accommodation. Your use of sick time could be part of the accommodation. Right?
That's what they told me originally. You were granted FMLA. The first 5 weeks would be sick pay, and then before they revoked it.
Mm-hmm.
So asking HR what the ADA process is my next step. Then I guess. Okay.
Alrighty.
Jen, another one? How about there's someone that I don't know the name. It's just a Galaxy. It's a phone.
Galaxy A10e.
That's me, I think, or might be somebody else too.
Nope, that's you.
Oh, I forgot what I was going to ask. Now, if you have to go back into a building that's supposed to be renovated, and people are passing out in there because of bad air, I'm sort of asking this question because of the people I work with. They might not be here at this meeting, but they need information, if that's all right. Because, where I work, the air is pretty stagnant, and people who have upper respiratory problems, who are on the respirators, are passing out in the buildings and even outside. Would they have a recourse for what would be their way of getting accommodations but still do their job? They come back to work and still teach the children, but the fear is not necessarily fear, but having people pass out in a building where the air is very bad. How can you get accommodations for that?
Well, it sounds like, what was your name? I'm sorry.
I'm Dorothy.
Dorothy, it sounds like, Dorothy, this was an issue that pre-existed COVID-19. And I would say that any building that has poor air quality and you believe that people are getting sick as a result, you file a complaint with the Connecticut OSHA. And they will come in and they'll do an investigation. They'll do an air quality testing to see, what's going on there, whether or not there are allergens in the air, whether or not there's dust mites. Mold often, is a major contributing factor to getting people sick. And if you need to, they'll shut the place down. Also, AFT National has a lot of good resources about dealing with sick buildings, like you're alluding to. I do know that, the CDC guidelines reference in a number of places the need for proper ventilation. And I know that a lot of you work in outdated buildings that do not have proper ventilation.
Yeah.
And that's a real problem. It's
It
a real
is.
problem. And all I can tell you is that you need to put them on notice that ventilation in your building's a problem. And if you think it's not being addressed, you can file a complaint with Connecticut OSHA, and they will investigate the complaint. They may come out, do an investigation. You should feel, and I would suggest that if there's a group of employees who feel concerned about the air quality in the building, that they file a complaint collectively, perhaps through the union. That will provide them some insulation from any, fear of retaliation.
Right.
They go through the union, file a complaint with KONOSHA that it's a sick building, the air quality is poor. Hopefully KONOSHA gets involved, does its job, does an investigation and remedies it.
Yeah, I was just, I'm not going to make this long. This particular building was supposed to be under renovation, was one of the buildings that was put on the list to be updated and renovated because of the quality in the building itself. But what if they do close the building down? What do you think would happen to the employees or the students? Is that?
I don't know. I don't know. That's
I know
speculative.
that's.
They'd have to start shuffling people around, but
Yeah. So that should be taken care of, and best way to go is through the union to make sure that they follow up with doing what they're supposed to do in the building.
absolutely.
Yeah.
Yeah, Dorothy,
That's
I was
all
going
right.
to say,
Thank you.
go ahead and put Shelley on them. Shelley and Jackie, they'll help you take care of the leadership.
Remember, Jackie is no longer with us.
Right, that's right.
It's Marta now.
Oh, Marta, I
Marta,
apologize. Yeah, but Jackie will make sure, not Jackie, Shelley will make sure it gets done.
Yep.
All right, so now let's go to, we have Kathleen and then Melody, and then we'll get back to the presentation. So Kathleen?
Yes, so I'm wondering to what extent could remote teaching be considered reasonable as an accommodation during this pandemic, and what would be the best argument to make to the district to get that accommodation for some of our members who might need it?
I mean, Kathleen, it's an excellent question. I think that it should be available as an option, particularly the older the student gets, the more likely virtual learning will be more and more, it will be effective, right? You can teach your lesson, your lecture virtually. However, if this district isn't providing it to anyone, it's going to be hard pressed to show that it's a reasonable accommodation if they created a blanket policy that no one gets it. That said, I think this is when your union can your building reps and your district reps can start to advocate, hey, listen, we have 30 employees who are asking for an accommodation here. Why don't we do a memorandum of understanding where we identify virtual learning for in these for the pandemic is a reasonable accommodation, recognizing that once the pandemic no longer exists, this won't create a precedent moving forward, creating permanent virtual learning positions. I mean, there's a lot of negotiating room that you have, and your union can step up and try to do that for you. I've seen districts, and I know some districts have entered into memorandums of understanding about the limitedness of virtual learning and the options for virtual learning and other issues like that. And I think that's when your union advocacy is important for the collective whole, because if one person's asking for an accommodation, there may be 12 people who are afraid to do so. So how can we make sure that everyone gets a fair shake in this process and make sure that, you know, we recognize the health and safety of all of you and all of the folks who are compromised.
Yeah, that really is the million-dollar question, Kathleen. You know, somebody who is at a high risk for contracting the virus, or is at a heightened risk for serious complications from the virus if they get it, can that person request an accommodation to teach online? And I think a lot of it's going to be contingent on what the reopening plan is. If the reopening plan has a online component, then why not make that available to those who need that? You know, that would make sense. So I think that's why it's also important to request the accommodation early rather than later. And for anyone who thinks they might need an accommodation to teach online, to the extent that districts are offering training on teaching online, you should avail yourself of that right away. Because then you can say, I'm trained, I can do it. This doesn't present an undue hardship to the employer. Part of our reopening plan has online teaching. I'm capable of doing it. It's a perfect fit, right? So the easier you can make it for them, the better.
So this is a related issue that I realize you may not have time to take up. Our students are being offered remote learning, as all students are. The current plan is for the teachers working full-time in the classroom to also be doing the remote learning. I don't know if you have any guidance on that.
Yeah, I know. And I think one thing that probably the unions are going to want to do is start to gather information as to how many students have opted out. If your district has a reopen plan that allows parents to opt their students out and participate only through online learning, how many of them are there? I think you want to know that. Because if there's a lot of them, then arguably there's more space, there's more opportunity for teachers who need an accommodation to teach online to do that, because we have, you know, 100 students who have opted out who need to avail themselves of online learning. We have 5 educators who need that accommodation. Let's put these 5 educators with these 100 online students. If you want to gather that, start to gather that information, you could do an information request saying and asking them specifically for the numbers. How many students have opted out? How many students are doing exclusive online learning? As far as the hybrid model, where students are in school part of the week and online the other, and teachers are expected to do both, that's going, I don't know how you guys are going to do it. That's difficult. And I'm still struggling with how that actually is going to work from a practical standpoint. And if anyone could tell me how that's going to work, I'm curious to know myself as a teacher. Melody?
Hi, thank you. Can you hear me?
Yes.
Okay, my name is Melody. I'm from New Haven, local 933. My question is, the governor has come out repeatedly and said that there will be accommodations made for teachers just as in the same way that they'll be made for students. And how does that play into this? Does his word override all of our worries here?
No. Short answer is no. You know, while the framework that we're operating within is with an existing law that was written to consider a non-pandemic situation. And unless there's a new law that's either passed by the state or by Congress expanding the way we understand the ADA, we have to operate within the framework that we have been governing by. Now, that said, right, you have certain rights for an ADA accommodation. If you personally feel that, you know, whether or not you're being there's a failure to accommodate, you may have a private on your own action against your employer through the CHRO. But that's separate from, you know, what your individual or union advocacy would be about, which is, you know, finding you the accommodation. But if you feel that you were, you know, you presented a reasonable accommodation and they just flat out denied you, and they didn't engage in the interactive process in good faith, and they weren't reasonable, and they didn't show an undue burden, even though you showed you had the disability, you could do your essential job functions and you propose reasonable accommodations, you may have a private right of action through the CHRO. But again, that's something external to, you know, our main conversation about requesting the ADA accommodation.
So to be clear, the governor's words mean nothing.
He's a politician. You
Just
know,
want
he's
to be
trying,
clear.
yeah, he's trying to appease people, trying to, you know, placate us, you know, is what he's doing, and saying everything's going to be fine. But that's doesn't mean much more than that.
And unless there's an executive order that comes out that extends, you know, makes it mandatory to provide a reasonable accommodation, their schools are going to still be able to say something provides an undue burden. And that, unless he changes that too. But as of right now, there's not an executive order to that effect. There's no new legislation that was taken up in the special session, and there's no new federal legislation changing the ADA. So as of right now, you know, we have to put forward a good faith effort to try to find individual accommodations based off of individual conditions.
Okay.
Thank you.
Last question, Rose. I'm sorry, Rose, let me. Okay,
Can
Rose,
you
I
hear
think
me?
you're unmuted. I can hear you.
Okay, my question is, if a para or a teacher is made to go virtual for accommodations, but they don't have the technology experience and stuff, can that be used as an excuse that we did try to accommodate you, but we're not able to?
Great question, Rose. Yes, it could be. It could be used as an example of an undue burden. So if, that's a great question. Should it be used? No, it should. No, it shouldn't be used. But could it be used?
No, I'm in a union. I'm in a meeting right now. That's why. Sorry.
That's okay. So yes, the answer is yes. It could be used as a district could say, look, we're able to accommodate you and have you teach virtually or work virtually. However, you don't have the ability to do it, the training, the experience. Maybe you don't have the internet at home. You don't have a computer that you can use. Maybe you have one computer and your child needs to use it for their online learning. So sorry, we're not willing, we're not able to buy you equipment. We're not able to bring broadband internet into your home, and we don't have the ability to train you within the next 10 days. Therefore, we're unable to accommodate you. That could be used, certainly. And that is a perfect example of what may or may not be used as an undue hardship on the employer in trying to meet an accommodation. Okay, so I'm going to start sharing my screen again. We'll move through some other topics. Can everybody see that?
Yep.
Okay, great. Okay. All right, James, do you want to start off on the CARES Act?
Yeah, so Congress passed the CARES Act back in April, I think, but it could have been March. Sorry, I don't remember the date. But the CARES Act provides paid sick leave under certain circumstances. One, if an employee is quarantined due to a federal, state, local government order, or because of a health provider order, is experiencing COVID-19 symptoms, they are entitled to 2 weeks, up to 80 hours of paid sick leave at their regular rate. So if you have a fever, and you believe you have COVID-19, you can email HR and say, I have a fever, I'm getting COVID-19 tested, I'm experiencing the symptoms, I'm going to be out until until these symptoms abate, or until I get the test back. You would be covered under the CARES Act for 2 weeks, up to 80 hours of paid sick leave at your regular rate. Now, if an employee is unable to work because of the need to care for an individual subject to quarantine, or to care for a child under 18 due to school closure, they are entitled to up to 2 weeks, 80 hours of paid sick leave at 2/3 their rate, right? So this is your kid it was in a classroom and they were potentially exposed to their being on a quarantine order, you're a single parent or you're dual employed parents, both of them, you know, somebody needs to stay home with the kid, you could be eligible under this one. And then you get up to 10 weeks additional paid expanded family medical leave at 2/3 the employee's regular rate of pay when you're unable to work because of a bona fide need to care for a child whose school has shut down or unavailable for reasons related to COVID-19. So this would be if you are still, so in addition to your child, if you are still experiencing symptoms past the 2 weeks, if you are still recovering, you know, this is where you get an additional 10 weeks at 2/3 your regular rate of pay that the employer would have to provide for you.
Okay, I'll talk a little bit about HIPAA and COVID. As we explained earlier, the employer is allowed to ask employees if they're experiencing symptoms, attributable to COVID. They are allowed to ask that. I know a lot of employers are going to be having employees and students filling out really short surveys. Have you had a fever? Have you been coughing? Have you traveled out of state? Those kinds of things. They are allowed to ask those types of questions, those types of screening questions. An employer may mandate testing and proof of test results as a condition of continued employment. They are allowed to do that. So if somebody travels out of state to one of these 32 states that are on Connecticut's advisory list and they come back, an employer could require proof of a negative test as a condition of continued employment. However, the employer, pursuant to HIPAA, is still required to keep all information private. Any of that information has to be stored separately. It doesn't go in the employee's personnel file. It's kept in a separate, confidential medical file and not to be shared with anybody else.
And just to jump in, Eric, for a second, I see a lot of folks putting questions in the comments. Let's wait until the end because we may answer your questions through the rest of the presentation. We do have a opportunity for questions at the end. That way your questions, which are important, don't get lost in the shuffle. Sorry, Eric, continue.
Sure. So if a staff member, teacher, parent does test positive for COVID, the employer may disclose the name of the positive employee to a public health agency, but not to coworkers. So I'm a teacher, I go to work, my employer then learns that I've tested positive for COVID-19. The employer, the school district, is going to relay that information to the public health agency. However, they're not going to tell my colleagues that I've contracted COVID-19. That would be a clear violation of HIPAA. They could, however, inform the staff that someone has tested positive for COVID-19. And they may want to inform the cohort of students that I was working with that someone that works with your child has tested positive for COVID-19. That type of information, quite frankly, should be shared. That's part of the contact tracing. That's part of how, hopefully, we'll be able to contain this virus if there are outbreaks after the reopening. But in any event, the employer cannot reveal the name of an employee who has tested positive for the virus. All right, so a little bit about unemployment benefits and COVID-19. James, do you want to talk a little bit about that?
Yeah, sure. So even though, so the basic principles of unemployment are an employee must be out of work through no fault of their own. They must be able and available to work. They must be actively seeking work, and they must meet the minimum earning or job tenure requirements to be eligible for benefits. This is the normal configuration about unemployment. And recently, Eric and I have received a lot of questions about teachers, paras, nurses, secretaries, educational employees, and they're asking, am I eligible for unemployment over the summer? And now I know the summer's starting to end, but the answer is no. Employees who work at educational institutions are ineligible for benefits if they work one academic year and there is a reasonable assurance that they will return to perform services in the second academic year. If, however, the employee is not offered employment in the second academic year, they may apply for retroactive unemployment. So many teachers are, they receive paychecks, at 56 weeks or 26 weeks, and they may not get paid for the duration of the summer. However, they have a reasonable assurance that they're going to be returning in the next school year. If for some reason due to COVID-19, the school does not start back up, you may be eligible for unemployment benefits because your position or the school is not paying you in the way that you expected them to do so. I will say that as part of this overall discussion point, something you can discuss as part of the ADA accommodation process is some type of a hybrid furlough sick time usage that may allow you to temporarily collect, but it's very limited and very, very fact specific. So I would not be jumping to unemployment as the savior because, again, based off of the basic eligibility requirements, you have to be out of work, you have to be able to work, and you have to be actively seeking work. And I think there would be a lot of problems trying to apply for unemployment because there was not an ability to accommodate you. And I want to hop back for a second, and this is, we can leave it on the question slide. This is a good place to leave it. About a little bit more about the CARES Act.
James, if you don't mind, don't forget what you're going to mention. But while we're on the unemployment, there was one thing I wanted to mention.
Yep.
And I'm going to try to pull it up on my screen. Maybe I shouldn't. I'm worried I'll mess something up. But the Department of Labor released some guidance recently about, as James said earlier, you have to be looking for work. And of course, if you're offered work, you have to take it. If you refuse work while you're collecting unemployment, you're no longer eligible for unemployment because you've refused work. The DOL recently came out with guidance that stated that someone who has one of these pre-existing conditions that makes them more at risk for either contracting the virus or suffering from severe consequences from the virus, they can refuse to return to work and still be eligible to collect unemployment because returning to work puts them at such great peril, at such great risk. They can say, no, I can't go back to work. I have this underlying condition that puts me at a heightened risk. Those employees could still be eligible to collect unemployment. However, the employer could contest it. They could say, we're contesting this, and more than likely there'd be a hearing on it. And at that hearing, the employee would have to show some type of medical documentation, some type of evidence to say, yes, I have this underlying condition. My doctor says I shouldn't go back to this job that I was offered to go back to. And if they can show that, more often than not, they would continue to be eligible for those unemployment benefits.
And the magic question, when you, if that is the situation you're faced with, there's a question on an unemployment application that asks, were you offered suitable work? You would say no, and then in the explanation area, you say you were not offered suitable work because you have restrictions, medical restrictions that would not allow you to continue your position in the way that they proposed. And so you would be, under that framework, eligible for unemployment. And I just wanted to touch on a couple things about the CARES Act. So I saw a question in the chat, and I just wanted to answer it for you about covered employers. Covered employers under the ffcra, the CARES Act, right, is private employers and certain public employers with fewer than 500 employees. So there are going to be some districts that may be larger than that, but generally, under 500 employees. Eligible employees, so on the other end, right, which employees are eligible? Anyone who's worked at least 30 days are eligible for up to that 10-week period of time. And this type of, I've had people ask me in the past, well, what if I don't want to take my 2/3, right? I don't want to take 2/3. I want to be in a situation where I take my my personal accrued time. You can do that. Just know you don't get 2 bites of the apple. You don't get to go back and then say, well, now that I've used my personal accrued time, I now want my 2/3 time. That would be 2 bites of the apple, and that's not how it's supposed to work. So I guess at this point, if people want to raise their hands, and Jen can highlight them, and Eric and I can try to answer your questions to the best of our ability.
Sure. Do you want to start with some of the questions that are in the chat, or do you want me to call on hands first?
Eric, what's your preference?
I'll look through the chat, do our best. I'll read them out loud. And
I'm looking at Linda R's. What happens if you use some of the CARES Act and test negative? And then a few weeks later, you have symptoms again and are asked to quarantine for other reasons. Do the days have to be used consecutively?
good question. I would think no. I don't think the CARES Act requires that the days have to be used consecutively. You don't need to use all 10 weeks. If you don't need all 10 weeks, you don't use 10 weeks. So good question. I would say no, they do not need to be used consecutively. Would you agree with that, James?
Yeah, I would absolutely. They do not need to be used 10. They can be used intermittently, especially if you're into a situation with your child care that you know, maybe your kid or your son or daughter are on one of those hybrid plans, right? They're in the school Monday through Wednesday, but they're not Thursday and Friday. You may need to take CARES Act leave on Thursdays and Fridays, but you don't have to take it consecutively.
Can an employer direct an employee to ignore symptoms that are pandemic-like? Absolutely not. You are suffering from symptoms, whether you think they're attributable to COVID or not. If you're feeling ill, you leave. And the reopening plans that I've seen all say that. They don't want you there if you're not feeling well. So no employer should direct you to ignore symptoms. And so if you're experiencing symptoms, you call out sick for the remainder of the day and you seek, either quarantine or seek treatment or do both. If you're not feeling well, see your doctor and let them know the symptoms that you're experiencing. Another question, does number 3 of the CARES Act include caring for an elderly parent who lives with me permanently? I'm trying to understand that question. So there is the provision of the CARES Act that affords you the 10 weeks of pay at 2/3 time to care for a family member. So you would be eligible for that benefit, that provision under the CARES Act. So hopefully I've answered that. Does the CARES Act cover required quarantine from being exposed to a COVID positive student?
So
go ahead, James.
my inclination on that would be, if you're exposed to a COVID positive student, there most likely will be a local government order, probably your local health director of your municipality, that would say everyone who's been exposed needs to quarantine or get a negative test before returning to work. So at that point, you would want to direct that question to the local healthcare or public safety or public health administrator, and they would be able to answer that question.
And I think the question is that, would they be covered? Would they be paid? So I think you would be paid for those first 2 weeks, those first 80 hours. If you're required to quarantine because you were exposed to someone who was positive, your employer tells you stay home, quarantine for 2 weeks, that would be covered by that first 80 hours under the CARES Act at full pay.
I have a question. Is there any way related to that?
Well, can we just so way everybody gets a chance, we're going to run through a couple more questions in the chat and then we'll go through the raised hands. One person asked, FMLA is paid leave under some circumstances. What are those circumstances? Typically, FMLA is paid leave when you're the one that's sick and you need the FMLA for yourself and you have accrued sick time. You can use your sick time and be paid while you're out on FMLA. A lot of that might be governed by your respective collective bargaining agreement where you work, the agreement between your employer and your union, so you want to double check that. But if the FMLA is for a family member, to care for a family member, then you as the para or the teacher are not sick and you may not be able to take sick time and you may have to use that time as unpaid. The other one I think I've answered. Rose. Okay, Rose asked a question. if you have symptoms and your employer wants you to go get a test, who pays for the test? That, I believe all COVID tests are free, or should be. And it should be at no cost to the employee to go get the test. If you're directed to go get a test and you're charged for it, and that bill should be submitted back to human resources, quite frankly. That the employee should not have to pay for a test they were directed to get. Let's see. CARES Act cover part-time employees? I believe that it does. Okay, let's go to some, we could spend all night in the chat room. Maybe some raised hands, Jen? How about?
You want to start with Galaxy A10E again?
Yes. And I believe that person's name was Dorothy?
Yeah,
Okay.
the governor is requesting before you return to school, I believe, that you do a self-test COVID-19. Now, do you know how that's going to work for people returning to school? I don't know if you've heard of it.
I'm sorry, say that one more time, Dorothy. I apologize, I was reading something. Sorry.
I think the governor is requesting that you do a self-test evaluation before you return to work to see if you have symptoms, COVID symptoms, that you have to do this self-test before returning to school or work.
So I think the governor was speaking to you taking your temperature and tracking to see if you have symptoms before you return to work.
Is that all that is? And would you have to report this to anyone in specifically? Or?
Well, again, you know, that's going to be that's going to be part of the screening process. If you take your own temperature and you have a temperature of 100 degrees or higher, you're going to need to disclose that, because you know, God forbid, you could have the virus. So you know, you are going to want to share that information.
Mm-hmm. Okay. Is there a guideline for what your temperature should be during this COVID symptoms? I guess you could find that information out.
Yes, it is on the CDC website, and my recollection was 100 degrees.
Oh, okay. All right. That's all. Thank you.
Yeah.
Okay. Next is Martha Rowland.
Yes.
Martha, you muted yourself.
Okay. First of all, if the ADA accommodations are denied, they say they're too much, then are we eligible for unemployment?
Only if you're separated from employment at that point in time. Hopefully you're not. Unemployment's only when your employment relationship ends.
Well, but okay, if they say that they can't do your accommodations,
Yeah.
what would be the other choice?
Well, then you would start using accrued time.
Well, okay, so you go back to the 5 weeks of sick time, but assuming there is no accrued time, wouldn't they lay you off if they said that there's no, we can't do that?
It's very potential that they could, but remember, they're going to argue, and you can anyone can file for unemployment. Whether or not you get it is a different question. They're going to argue at the unemployment hearing that you were offered a suitable position and a suitable accommodation, and that you declined it. You know, they're going to say, let's say you have the mild asthma, right? They offered you a face shield, and you said you didn't want to go to work, and your doctor's note only says, you know, she needs to have additional levels of protection.
Yeah.
So the question then will be at the unemployment hearing is, can you show that you were not offered a suitable position?
Okay.
Which is a different standard than were you offered a reasonable accommodation. And earlier we mentioned that you may still have a private right of action at the Connecticut Commission on Human Rights and Opportunities, CHRO, by filing a complaint saying that the school or the employer failed to reasonably accommodate me, a failure to accommodate claim, which would be separate, you know, from you know, the ADA process itself, or separate from the unemployment process. So, you know, you can say they wrongfully terminated me on the basis of my disability, and they failed to accommodate me.
Oh, and that would be a union.
That would not be through the union. That'd be individual through you. or through the employee by themselves.
Okay, so you get somebody who's a lawyer.
Correct. You would get
Or
you can, there's nothing that stops the CHRO process from going on by yourself. I would advise always consulting an attorney first. But again, the goal and the reason we went through the ADA process in such detail is because the goal is to try to get everyone to keep their job and to make sure that they can save their jobs. We don't want, but at the same time, we recognize, and I recognize especially, that pre-existing health conditions are real, and that, you have to balance the interests of being healthy and safe and doing your job. And honestly, your health and safety should always come first.
One other question, and I'm sorry if you already covered this, is self-quarantine. Let's say your doctor says, okay, you need to self-quarantine, covered under the CARES Act.
Yes.
It is. Okay.
It would be under that first bullet that if employees quarantined due to ... healthcare
Yes.
provider order.
Okay.
So in that situation, what I would suggest is you get a doctor's note with the order and you submit it to HR or to your building administrator.
Okay.
So someone asked a question in the chat, and I'm surprised it didn't come up sooner, about age. So absent any other of the risk factors that we went over, cancer, immune deficiency, cystic fibrosis, those types of things. Absent something like that, is age alone, would that result necessarily in an accommodation? And the answer is no, it wouldn't, not by itself. Even though the CDC and every other health professional has acknowledged that people 65 and older are at increased risk of suffering from the virus, more than others, that in and of itself isn't necessarily grounds for, would consider you disabled and therefore would be grounds for an accommodation. So again, though, you're going to want to talk to your primary care physician, your doctor, about your increased risk. And if your doctor thinks that based upon your age and perhaps other underlying health conditions that you are at an increased risk of suffering from the virus and therefore need accommodations, then you're going to want to have that conversation with your doctor. But just 65 and older gets an accommodation? No.
Eric, I'm going to keep going with the hand raise. I will ask people to try to keep it as brief as possible because we have more hands popping up and we are getting closer to our end time. So with that, Michael, I'm going to pronounce it wrong. Soares?
Good afternoon, Mike Soares from New Haven. Question, if a teacher finds him or herself in a situation that's realistically unsafe and out of compliance with the district or state recommendations, what would be an appropriate course of action? It doesn't seem like comply and grieve would be appropriate. Any thoughts or recommendations on how an individual teacher might proceed in documenting the situation and whom they might direct that to? Thank you.
Great question, Mike. Thanks for asking it. Yeah, I think you want to do a couple things. One, you want to make the building level administration aware of it right away. Document it if you can, even if it's just in an email. Make that complaint known. I know sometimes if it's something urgent, sending an email isn't practical. You have a bunch of students who all of a sudden are not wearing their masks and not adhering to social distancing and other precautionary measures. Sending an email doesn't help you. But what I mean by that is once you let the administrator know right away, hey, this is happening. This is not in compliance with our reopening plan. It's not in compliance with CDC guidelines or the State Department of Health. I would then just follow it up later with an email. So it's documented. It's timestamped that you let them know. That's number one. And you should insist on an immediate response. The other thing you can do is you can file a complaint with konosha. That's the Connecticut agency that governs, administers, and assures workplace safety. And you're going to want to file a complaint with them right away as well. There are provisions in OSHA that state that an employee can refuse to enter an unsafe work environment. However, it's got to be a serious risk, and not, it may not be one where, you know, a student isn't keeping his or her mask on all day. That may not rise to the level of invoking that specific regulation. But OSHA does have statutes and regulations that say you can't be made to walk into a work environment that you reasonably believe is going to be imminent risk to your health and safety. So you can exercise that right if you need to. And again, to my point earlier about making a complaint, I think you want to do it collectively. I think you want to do it in concert with some of your colleagues. I'm sure your colleagues are going to have the same concerns. If you could do it as a group, the more people speak up, the louder your voices are, and the more they're heard, and the more insulated you are from any type of reprisal. If 10 teachers come forward, they're not going to do something to 10 teachers as quickly as they might do to one. So make that voice loud and make it come from as many people as possible.
All right, we'll do Melody Gallagher.
Thank you, Melody, again, also from New Haven. I asked this question in the chat, but I actually just received this text from a colleague while we're on this call, so I figured I'd ask in the chat. Apparently in Darien, at the Board of Education meeting the other night, the head of HR there stated that due to the 35 people who applied for ADA accommodations, that they would be advertising all 35 positions today as anticipating openings. And I haven't gotten a response yet, but I don't believe that they went through the ADA process that you had just described of kind of going back and forth with people. And so would that mean that they weren't following ADA procedure is my first question. My second question is, you know, this is now a district in Connecticut that has done this. People are already calling legislators about it. How does that affect us collectively? I know that's not our union, but those of us that are in other districts, if our district were to try something like this, what do we do?
So that's a great question. You know, I don't know all the facts about this Darien situation, but let me just say this. The rights that you have through the ADA or any other law are only as good as the ability that we have to enforce them. If the schools or the employers are actively ignoring the law, actively disregarding the law, and actively ignoring your rights, you have the ability to get recourse or find recourse for it. So if there's a collective group action, you may want to consider a collective group action back at the CHRO, file a complaint, say this district is not complying, and here are all the complainants, you know, have all the complaints, co-sign it, get legal counsel, and go after them. You know, I think that we all have a responsibility collectively in this profession. Well, I'm not an educator, I know all of you are, but as somebody who supports and tries to fight for educators, we have to make it very clear that we're not just going to let something go. So running to your legislators, getting public support is important, but making sure that, you know, you're measured in how you do it and how you approach it.
Yeah, and I too, Melody, I read that, and I think it was Dorothy was asking a question. I was reading that, I got distracted by it because it kind of jumped out at me. I wasn't aware of it. Darien is a relatively small district. Again, I don't know what the ADA accommodations were. If 35 teachers submitted ADA accommodations at the same on or around the same time, saying, you know, unless you can do these things, we're not coming back. And then the district in response says, okay, we're posting these positions. You know, that they may be leveraging one another. You know, there may be some real competing interests going on there, and that I'm not aware of, and I wouldn't want to speculate. If these 35 people were kind of acting in concert, saying, you know, maybe perhaps there are 35 teachers who are over the age of 65, and say, you know what, we're going to all put in requests for accommodations that we can only teach remotely. And the district says, okay, you know what, we're going to post these positions because we don't have remote learning. You know, it could have been something like that, where I can see a line being drawn in the sand on that. But let's assume, for the sake of your question, that these 35 individuals all put in for their own individual specific accommodations, and then the district just unilaterally posts 35 positions, I'd say they certainly were not complying with ADA. They have to engage in the interactive process with each and every individual who requests the accommodation. They have to sit down with you, whether it's like we're doing here or face-to-face, but they have to engage the person in that interactive process. Read what the doctor's report says, read what the restrictions are, and say, well, what about this? And the employee says, well, I can do this, and you start that back and forth. If they don't do that, they are clearly in violation of the ADA, and any individual can file a complaint with the Commission on Human Rights and Opportunities, and then ultimately litigation if they need to.
Thank you.
All right, let's do Linda R.
Can we, I'm sorry, I think Linda, I know we're getting close, it's 6:30, and I see a couple names of people who haven't asked a question yet.
Oh, okay.
Would it be okay to, I don't think we've heard from Patty, Patty Stewart, I'm gonna unmute you.
I did put my question in the chat if you have a chance to look at it.
Hi, thank you. My question is, my town requested in mid-July us to say whether or not we could teach in person based on either childcare, our health, or the health of somebody that we lived with. So I submitted a letter from my husband's doctor describing his significant severe medical conditions. And she stated at the end that preferred family members need to work from home or work in a job that does not place my patient in risk. I submitted it to personnel. They then emailed me a letter that a form that they were submitting to my doctor, which was the public school building safety measures. And based on the safety measures, they said that I have 10 federal EPSLA days, and after that I would have to take an unpaid leave. And I'm not sure how I should proceed or if I have any grounds to proceed.
Yeah, I'd have to get some more facts from you, Patty, to really answer that specific question. I don't want to dismiss it. It's important, but okay. I would need to know more about your specific situation to really address that.
Also, just to kind of add, I'm a special ed preschool teacher with 3- and 4-year-olds in a self-contained class. We attended our first meeting with our school on Monday to unveil the plan for reopening. There's no plan yet for our program because they haven't heard from the state yet what to do about us. Our students aren't going to be required to wear masks because of their age. I can't even imagine what my classroom is going to look like, and nobody seems to know yet.
They don't know, Patty. They don't know.
I know.
They don't know. And what I can tell you is I don't want to put out misinformation, but I've seen drafts of documents that are being formulated that talk about special ed students and their teachers and the paras who work with them, and students who, due to their diagnoses cannot wear a mask.
Yes.
Either behaviorally or medically they can't wear a mask. And I've seen drafts of documents where they're talking about in those situations, the employee will be donned in full PPE,
yes.
N95 mask, face shields, gowns, gloves, the whole thing, with some type of mechanism where the students are, unable to get close to the teacher. It's going to be a Herculean task for you guys to do it. But getting back to the first part of your question, did you request an accommodation?
What I did, and this is another thing, like I didn't see this form about their school safety measures until after I sent the letter from my husband's doctor. And I said, why didn't I receive this form first? And she goes, well, it wasn't done. that form would have been helpful to submit to my doctor, my husband's doctor, along with my request.
Yeah. And what I will say, Patty, is remember I think you may have said ADA or somebody said ADA. ADA does not cover a spouse.
Yeah,
so
I know. Yes.
Yeah. So, you know, what I would say is that, again, to Eric's point, it's a very fact-specific situation. We may need to have a longer conversation about what the restrictions are and what specific plans are to address it. I don't know if there's a magic answer that we can come up with.
Okay.
How about, is it Y Chen, Mr. Chen or Miss Chen?
Hi, how are you? My question could be easy. What can the worker comp play in this COVID-19 if I got infected in school?
I'm so glad you asked that, and I meant to mention that, and thank you for asking that. So if any educator has a known or suspected exposure at work, you got to do a couple things. You got to document it. Number one, you're going to want to document it in two ways. Number one, you're going to want to file some type of incident report that this happened, that you were informed by administration that one of your students tested positive for COVID. Okay, or whatever it is you were informed, or exhibited symptoms associated with COVID. Okay, so they let you know, hey, one of your students, you have a potential exposure. You document that. Okay, that's number one. Number two, you're going to do whatever it is you're told to do. If you're told to quarantine with the rest of the cohort of the students, you're going to quarantine. You're going to be paid for those first 2 weeks under the CARES Act. Regarding workers' comp, if you experience symptoms or if you get a test, either one, you're going to want to file what's called a Form 30C, a workers' compensation claim. And you're going to, and that's available online. And I think we've sent out some documents through AFT Connecticut with links to that form. But you're going to fill that out. You're going to file a workers' compensation claim that you contracted COVID at work. So yes, you're absolutely going to do that. If, however, your administration says you have a potential exposure, stay home for 2 weeks, and you have no symptoms, you never test positive, I think you still want to document it. There's a lot we still don't know about the virus. Maybe you wind up getting a positive test later, but you document it with an incident report and just kind of hold it in abeyance. If you never contract the virus, hopefully you dodged a bullet and you're fine. But if you get diagnosed with COVID due to a workplace exposure, you're going to file a workers' compensation claim. Absolutely.
Thank you.
How about Nika Turner? Nika, I think you should.
Can you hear me?
You're kind of breaking up a little bit.
Can you hear me? Okay. I'll try to see what I need to say if you can hear me.
Nika, we can't hear Nika. We can't hear you at all.
Is what does social distancing look like for students with special needs?
Gotcha.
Nika, I'm sorry, I couldn't hear anything.
Eric, it's in the chat as well. What does special education social distance learning
Can
look
you hear
like?
me?
Okay, what does special education social distance, I think you meant, look like? Yeah, that's going to be difficult. And I think, like Patty said earlier, they don't know. And I think if they try to tell you they do know, they're misleading you. They don't know. We're all trying to figure it out. especially with paras and special ed teachers. The one-to-one paras who, you know, escort these students around the building, are there with these students. They often have to use physical prompts, you know, to keep the kid focused. How you do that, quite frankly, is beyond me. I don't know. James, are you raising your hand or are you fixing?
No, I'm fixing my camera.
All I would say, Nika, and to anyone else in this situation is, you know, do the best you can to keep yourself safe. And if you're working with a student who's not donned an appropriate PPE, you have to insist that you be equipped with full PPE if the student's not going to be wearing a mask. And there's nothing wrong with asking that question. And again, it's always best, I think, if the question comes from a group as opposed to one person, because I don't want someone saying Nika's a troublemaker. If it comes from Nika's union rep, if it comes from Nika's union president saying, how are you, the administration, going to deal with social distancing for special education students? You know, let it come from them, because they're not going to retaliate against a union official. I don't want to put more work on our union officials than they're already faced with, but you know, we can help insulate you from that kind of retaliation. But yeah, I don't know what it's going to look like, Nika. It's a great question. Maybe a few more, Jen. I know we're about 10 minutes over now.
Yeah, Doreen has I don't think Doreen's gotten a chance to speak yet.
No. If you go away to a hot spot over the weekend and you're asked to quarantine, are you covered?
Good one. There is no statute on that. There's no regulation on that. I mean, would you have to use sick time? Perhaps you may have to use sick time. That might be something that you want to work out. Perhaps the union and the employer want to work out through a memorandum of understanding. If you have to go out of state, let's say you have to attend a family funeral, for instance, and you have to go to
or a birth of your first grandchild.
Yeah, something like that, right? That's a much better example than mine. And you come back, something like that, you know, they shouldn't charge you sick time. Now they're going to want you to quarantine. They are going to want you to quarantine. You're going to have to quarantine consistent with the governor's executive order. So you have to. The question is, how is it counted? Is it charged against your sick time, or is it just going to be, you know, paid administrative leave? That might be something you want to try to bargain over. If you're going, you know, for an extended weekend to celebrate an anniversary, then maybe that's sick time. If you want to celebrate the birth of your first grandchild, maybe that's paid administrative leave.
And what I will add, Doreen, right, is this is all new, right? I think you would have a good faith argument that it would be covered under the CARES Act, because if you read the exact specific language, it says due to a federal, state, or local government order. So you could argue that the governor's order is that if you return from these states, you need to quarantine for 14 days. Now, this is all developing. It's about application of the law. So there may, I think that's what Eric's talking about, right? You may want to start with a memorandum of understanding so that, you know, let's say you do come back and they say, take your sick time. That way, if you get exposed by a student, then you're not sitting there saying, well, I've already used my 80 hours. What do I do now? So trying to figure out what that sweet spot and that balance is really important, because unfortunately the federal law doesn't go as far as I would like it to go in protecting employees.
Thank you.
Maria?
Hi. Can you hear me?
Yes.
Hello?
I can hear you. You're a little choppy, but I can hear you.
Okay. I just wanted to ask, I don't know if you've covered it already, but
Okay, so you were saying something about if you were exposed to a student who had COVID and they tell you to quarantine because you were exposed, and it's not, you know, your fault, it's somebody else, you know, you were exposed. When they tell you to quarantine, and you said that you have to quarantine for 2 weeks, are you actually using your own sick time, or you're not?
You should not be using your own sick time during that quarantine. That's covered under the CARES Act. You're paid for those 2 weeks at full pay.
Okay, all right, thank you.
Okay, Linda and Rose.
Okay, my question was pretty quick. In the PowerPoint that you showed, it said that the schools can mandate testing, or the employer can mandate testing. And we had a virtual town hall meeting, and one of the CEA recommendations was that all staff and students entering the building would be tested weekly. They said they're not even doing temperature checks, and they said they cannot force anyone to take a test. So if you're not going to catch the asymptomatic people, if you are exposed to something after so many days, you should be able to get tested. So if you just choose not to get tested, you're going to take those 2 weeks. So how, like, that just contradicted what our head nurse said. So I'm just wondering, they can mandate testing, correct?
So yeah, they may mandate testing, they can, but different districts may have different reasons for not wanting to do it. Maybe they're afraid of legal challenges, maybe they're afraid of, maybe they have concerns about being able to maintain the privacy of that collection problem. A big problem that happened earlier in the summer, before the plan started coming out, was there was a question about, will teachers have to be taking temperatures of students? Will paras have to be taking temperatures of students? Will the bus driver? And the question then became, well, that's not their job. They're not nurses. They're not trained medical professionals. What are they supposed to do once they get a positive test? So a lot of districts have just opted out of the testing altogether, saying self-test, self-temperature check, and flag if there's a problem. So different districts have approached that differently. But under guidance that has come out from DOL, from the EEOC and other sources, they may mandate testing, whereas before HIPAA would be you were prohibited from doing a medical test that is non-business related. They said, you know what, it is business related. Making sure that people don't have COVID is now considered business related under HIPAA, so they may, but they may mandate it, but that cuts the other way. They may not mandate it. It's my position that I think that there should be some level of testing to ensure all of your safety and all the students' safety, but districts have different considerations that they're balancing.
How about Roberta? Roberta, can you, I've tried to unmute you. You might have to unmute yourself.
Sorry, I was talking to myself there for a quick second. It was about the CARES Act, and my question is, if I have to make a claim, say, you know, the birth of the first grandchild happens, and then a month later I have to go out of state for another reason, does that renew for another 2 weeks, or do I now have to use sick time if I have another mandated quarantine for a valid reason?
It does not renew. One of the problems with the current act is it assumes that you're going to be exposed once and then you're done. So it does not renew. Now, what I would argue is that you should, try to work that out with your employer. One of the things that the CARES Act does say is you get 10 weeks of paid extended family medical leave at 2/3 your regular pay. But that's related to childcare and related to the childcare needs beyond that. So they only offer you 80 hours directly related to a quarantine. So if you can be creative and try to find ways to loop in something else, that's good. But unfortunately, the federal law doesn't go far enough to prepare you for the scenario that you're presenting. At that point, what you could try to do is, let's say you've already used your 80 hours up, you could try to come up with a hybrid sick time FMLA combo to be able to carry you through that period. Or, you know, again, maybe the district would like to do a memorandum of understanding with the union that during this period of time of COVID-19, that they're willing to pay some percentage of the salary if there are subsequent quarantines after the first one. Or they can say, potentially that's the point where they say, well, you're in quarantine, but let's have you do remote learning. We don't know what September is going to hold, but those are all possibilities.
And I guess the other part, I guess the other clarification I need is, so if let's say the exposure is at work, then that would be a possible workman's comp.
Yep, just like Eric explained earlier.
Okay. Yep.
Okay, cool. Thank you.
All right, can I just real quick, let's do one question from Abby in the chat, and then we'll do Rose, and then we have to shut it down. So Abby just asked real quick, does the CARES Act cover part-time employees?
Yes, it covers everyone. Every employee that's been there for more than the 10 days.
And Rose had a question.
Yes, you mentioned asymptomatic people and children, preschoolers without masks. What happens if you get sick, but nobody has been classified as being COVID in your cohorts, your coworkers or your students, but you did get sick? We have kids that come in sick and the parents give them Tylenol and send them to school. So we wouldn't recognize them being sick.
Every day that happens, right? Every day parents give their kids Benadryl, Tylenol, and wipe their nose and send them to school. That has happened before COVID. That's going to happen. You can bet your bottom dollar that's going to continue to happen. Hopefully it happens less. People are taking this a little more seriously, but certainly, Rose, that kind of thing is going to continue to happen. And the reopening plans that I've seen will say that if a para teacher sees any of these symptoms, fever, cough, etc., that you send that student to the nurse. And the nurse, every nurse's station should have a designated room to either administer a COVID test or do an assessment of the student to see if maybe he or she has symptoms associated with COVID, call the parents, and have the kid brought home. So you're going to continue to do that. I think the only difference now is, go ahead, Rose, I'm sorry.
My question was, if I get sick, but none of my students are sick and none of my coworkers are sick at that moment, I'm the first one to get sick.
Yeah.
Would I be able to collect workers' comp during my sick time? And how will it be proven that I got it at school and not somewhere else? Because that's the first thing the district's going to say. You got it from somewhere else.
That's right. You're right. And the burden is on you to prove you got it at work. So I forget who asked the question earlier about, I think it's someone from New Haven, Mike asked about it, or I forget. But in any event, yeah, it is on you to prove it. So if you're the first one to get sick in your building, can people transmit the disease without showing symptoms? Absolutely, they can. That's going to make it difficult for someone like you, Rose, or someone else to prove that I got it at work when you can't identify an exposure. You're right. That is going to be an obstacle. There's no way around that. Was that the last one, Jen?
Yeah, well, it's close to 7, so I think we probably need to wrap up. But thank you, Eric and James, for an absolutely brilliant, very insightful workshop. I hope everybody got a lot out of it. Just so everybody knows, we are going to have this workshop again. So if you have coworkers who are interested in attending, or you think it'd be helpful to have them join on August 24th, Eric and James will be doing this all over again. Sorry, guys.
It'll be good. We'll know more. We'll be closer to the reopening. And yeah, and listen, I just want to say, thank you for all you're doing, and thanks for participating in this and for all of your questions. I know there were some we weren't able to give hard and fast answers to, and as we evolve through this, hopefully, well, there's going to be more questions and perhaps not as many answers, but keep yourselves as safe as you can.
Yep.
And just know that, you know, your union's there to support you. We're here to support you. That's it. That's all I have.
Yeah. I want to echo Eric's comments. You know, I think the job that educators, you all do, supporting students is so important and so vital. And, you know, we're here to support you through this process. And I know we don't have all the answers, but, you know, I hope we were able to give you guys some insight into the basic principles that we're operating under. And, you know, as things continue to develop and evolve, AFT will continue to put out as much information that they can so that you can all be informed. And again, encourage your coworkers, friends, colleagues to come in 2 weeks from now, and we can continue the conversation. Hopefully we'll know more by then. We're always looking up things and researching things. But thank you all for all the work that you all do. We appreciate you.
And I will be sending out this recording to all of you. I have your email addresses from when you registered. So with that, good night, good luck, stay safe. Thanks, guys.